Contingent contracts, sections 31 to 36, Indian Contract Act, 1872. Meaning. A contingent contract is a contract to do or not to do something if some future uncertain event happens or does not happen. The performance of the contract depends on a condition. In simple words, it depends on an event. A contingent contract is a contract in which the performance of the promise depends on the happening or non-happening of a future uncertain event. In such contracts, the parties agree to do or not to do something only if a specific event occurs or does not occur. Under the Indian Contract Act, 1872, contingent contracts are recognized as valid contracts. The important point is that the event on which the contract depends must be uncertain and collateral to the contract, not a part of the promise itself. For example, if A agrees to pay B 10,000 Indian rupees if B's house is damaged by fire, this is a contingent contract because the payment depends on an uncertain future event. Contingent contracts are commonly used in insurance contracts, guarantees, and indemnity agreements. The law clearly lays down rules about when such contracts become enforceable or void, depending on whether the event happens or not. Definition, Section 31. A contingent contract is a contract to do or not to do something, if some collateral future uncertain event happens or does not happen. Essential elements of a contingent contract. The essential elements of a contingent contract are as follows. Existence of a valid contract. A contingent contract must first satisfy all the essentials of a valid contract, such as lawful consideration, lawful object, free consent, and competent parties. The first and most important requirement of a contingent contract is the existence of a valid contract. This means that before a contract can be called contingent, it must fulfill all the essential elements of a valid contract as laid down under the Indian Contract Act, 1872. For a contract to be valid, there must be offer and acceptance, lawful consideration, lawful object, free consent, competent parties, agreement not expressly declared void. If any of these essentials is missing, the contract becomes void or voidable and cannot be treated as a contingent contract, even if it depends on a future event. Thus, a contingent contract is not a separate type of agreement but a valid contract with an additional condition that its performance depends on the happening or non-happening of an uncertain future event. Dependence on a future uncertain event. The performance of the contract must depend on the happening or non-happening of a future event which is uncertain. A contingent contract must depend on the happening or non-happening of a future uncertain event. This means the performance of the contract becomes enforceable only when a particular event occurs or does not occur. The event must be future. It should happen after the contract is made. Uncertain. It may or may not happen. If the event is certain to happen, the contract is not a contingent contract. Example. A agrees to pay B 50,000 Indian rupees if B's ship returns safely. The return of the ship is a future uncertain event, so the contract is contingent. If the event never happens, the contract may become void depending on the rules given in the Indian Contract Act, 1872. Thus, dependence on a future uncertain event is a core feature of a contingent contract, and without such uncertainty, the contract cannot be called contingent. Event must be collateral to the contract. The event should be independent of the promise and not form part of the consideration itself. In a contingent contract, the event on which the contract depends must be collateral to the contract. This means that the event should be independent of the promise and should not form part of the consideration or the main performance of the contract. The event must only act as a condition that decides whether the contract will be performed or not. If the event itself is the promised act, then the agreement is not a contingent contract. Example. A promises to pay B 10,000 Indian rupees if B's house is destroyed by fire. The destruction of the house is an event independent of the promise, so it is a collateral event, and the contract is contingent. But if a promises to pay B 10,000 Indian rupees for destroying B's house, the destruction becomes the main act and not a collateral event. Such an agreement is not a contingent contract and is also illegal. Therefore, for a contract to be contingent, the event must be collateral, meaning it should be separate from and not form part of the main promise of the contract. Event should not be at the will of the promisor. The event must not depend solely on the will or control of one party to the contract. In a contingent contract, the event on which the contract depends must not be under the control or will of the promisor. If the happening or non-happening of the event depends solely on the wish or decision of one party, the contract will not be treated as a valid contingent contract. The reason is that a person cannot create an obligation that depends only on his own will, as this makes the contract uncertain and unreliable. Example. A promises to pay B 10,000 Indian rupees if A feels like paying. This is not a contingent contract because the event depends entirely on A's will. However, if A promises to pay B 10,000 Indian rupees if a ship arrives safely, the event does not depend on A's will, so it is a valid contingent contract. Conclusion. Thus, for a contingent contract to be valid, the event must be beyond the control of the promisor and should depend on an uncertain external factor. Uncertainty of the event. The event must be uncertain at the time of making the contract. If the event is certain, it is not a contingent contract. In a contingent contract, the event on which the contract depends must be uncertain at the time the contract is made. This means it should not be known whether the event will happen or not. If the event is certain to happen or impossible from the beginning, the agreement cannot be a contingent contract. Example. A agrees to pay B 20,000 Indian rupees if it rains tomorrow. Rain is uncertain, so this is a contingent contract. But if A agrees to pay B 20,000 Indian rupees if the sun rises tomorrow, the event is certain to happen, so it is not a contingent contract. Conclusion. Therefore, uncertainty of the event is essential in a contingent contract. Without uncertainty, the contract loses its contingent nature and becomes either a simple agreement or a void agreement. Lawful event. The event on which the contract depends must be lawful. If the event is illegal or impossible, the contract becomes void. In a contingent contract, the event on which the contract depends must be lawful. This means the event should not be illegal, immoral, or against public policy. If the event is unlawful, the contingent contract becomes void. The law does not allow enforcement of contracts that are based on illegal acts or forbidden events. Example. A agrees to pay B 50,000 Indian rupees if B smuggles goods successfully. Smuggling is illegal, so the event is unlawful and the contract is void. But if A agrees to pay B 50,000 Indian rupees if B wins a court case, the event is lawful and the contract is valid. Thus, for a contingent contract to be valid and enforceable, the event must be lawful. Any contract depending on an unlawful event has no legal effect under the Indian Contract Act, 1872. Conclusion. A contingent contract is a valid contract whose performance depends on the happening or non-happening of a future uncertain and lawful event. For such a contract to be valid, all essential elements must be present, including the existence of a valid contract, uncertainty of the event, collateral nature of the event, independence from the promisor's will, and lawfulness of the event. If any of these elements is missing, the contract cannot be treated as a contingent contract and may become void or unenforceable under the Indian Contract Act, 1872.